Yes.
My Lord, may I make three very short points?
Yes.
The first is in answer to Lord Justice Holgate's question about policies. What we propose to do is there are 8 various policies, is just to provide the court with a note of the policies, that they're statutory, non-statutory, and the cross-referencing in the bundle, because that will save a bit of time rather than my telling you now about those.
All right, if it's simply a list without argument,
yes,
that's fine.
Obviously,
yes,
and
right.
The likelihood that this can be agreed in any event and
yes.
then submitted to the court. It just, I suggest that because it saves a lot of time in my taking you to each one
yes.
and explaining that to you. That's the first point. The second one is to highlight...
Just before we lose that, could you please run it past Mr. Glenister?
Yes, of course.
And hopefully should be agreed.
Yes, that's sorry.
Right. That's point 1.
And it might be helpful if there was joint highlighting rather than having to go through every last part of the policy that you.
No, of course, yes. And in fact, yes, I did say we hopefully. I imagine it'll be entirely uncontentious. We can agree it and submit it.
Good.
Yes, of course. The second point is, my Lord, to highlight that in respect of what appropriate measures are, that we say these, in this case, would have included the carrying out of a focused inquiry in reviewing the PEC's decision. That's the second point. And the third is a clarification point in respect of this appellant and an update on his position. At the very outset of the hearing, I addressed you on the GCSEs he was doing, and the clarification is that he's not yet been entered for his GCSEs, but he's been assessed to sit for English language, English literature, maths and science, and they will be capped. That means that they will be capped at a level 5, which is the equivalent of previously a C, and to make the point that children usually take around 9 GCSEs. So that's a clarification.
In your update, in your supplemental skeleton, you said that he was considering taking the exams a year later.
Yes.
And he was going to the Education Authority to discuss that. What came up about it?
So there was going to be a meeting. There wasn't that meeting, and now the position is that he needs to enter for these exams by the end of February.
I see.
And so they're going. That's at the moment. He's with his home tuition. He's going to. Yes, he's going to enter for these, my Lord.
Thank you.
Thank you. In that case, those, unless I can assist the court further, those are my submissions.
Thank you very much.
Thank you, my Lord.
My Lords, I intend, as probably expected, to address you first on ground 1 and then ground 2. And then after I do that, there's a few mop-up points, particularly in relation to the intervener submissions, but I'll deal with those primarily separately. In terms of ground 1, which I'll launch straight into, I was going to deal, subject to questions from the bench, to deal with it by dealing with 4 issues that go directly to the ground of appeal, and then 3 issues which have arisen in the discussions this morning, but most of them are quite short, so we shouldn't spend much time on each one. So that's my framework for ground 1. Starting then with the first issue on ground 1, which is what is the relevant legal question that is under appeal. And in my submission, the starting point is to identify the 2 separate questions which arise when you're looking at the Article 4 protection duty. And I've set these out at my skeleton, paragraph 15, and I identify them as, firstly, the first question is whether the state authorities were aware or ought to have been aware of circumstances giving rise to credible suspicion that, in here, RWU had been or was at a real or immediate risk of being trafficked. Those are the familiar words that you'd remember from TDT. So that's question 1. Question 2 is if and only if that first question is satisfied, do you then look at the protection duty and determine what appropriate measures should be put in place. And so in terms of authority, just to hang my hat on, that's in TDT at paragraph 18. It's on page 188, or whether you need me to go there or...
No, if all you want is that quotation,
yes, that's,
then that's fine.
And so here, perhaps I don't need to go to the judgment, but what Mr. Justice Fordham found was step 1 was not satisfied, the trigger wasn't satisfied, and therefore he didn't need to look at appropriate measures. And that's at 66 of the judgment. Yes. So the entire judgment was on that step 1. Was the trigger was the duty triggered at all? And so I say what this court is looking at, and appeal ground 1 must be on, in terms of the error the judge came to, it's in the analysis of that first question of whether there was or ought to have been credible suspicion.
As at 24th June.
That's what there was an issue about this below, and it's one of the points I was going to address you on later in my 3 points that I'm not sure material to the appeal, but I was going to make points on that. I don't think it matters.
Well, if the appeal is allowed, it would.
It would, exactly.
Yes, as would also the protective measures.
Correct. Yes, Judge. Yes, my lord.
Well, let's just shelve the question of subsequent events.
Yes.
The decision, which is the subject of the judicial review, is the 24th of June panel. Now, looking at the TDT question, whether the state authorities for this purpose is the governor's disciplinary panel, is it not, were aware or ought to have been aware of circumstances giving rise to credible suspicion that an identified individual had been or was at real immediate risk. Can I go back to the point we were discussing with Ms. Braganza just before the lunch break? The governor's disciplinary panel had, or surely should have had, the decision of the IRP allowing the appeal against their original decision and sending the case back to them. Might it be said that the panel should have been aware of the worry about CCE from a reading of the panel decision, if nothing else?
I say, I'll take you to the relevant passages. It was aware of the assertion of CC or grooming, as it was stated, and it dealt with that head on. So, I mean, shall I, instead of, I was going to take you through a bit of a timeline of the documents. Shall I do that now? And the IRP sort of jumps in halfway through, if that's
all right.
Okay. And so I'll just make that, deal with that. So, it's from my skeleton argument. If I pick that up because it refers to documents, we can go to the underlying documents if it's helpful. It's a paragraph 21.
Yes.
So, and there, everything is extracted, so it makes it slightly easier. So, if we look at what the head teacher or the principal was considering as at the time of the 18th of January, he was asked about that at the IRP, and I've extracted the extracts at 21 and 22, and I invite the court to read those, but effectively he had considered the circumstances in the round, and he spoke to parents about the concerns, and there weren't any concerns about criminal activities. That's a high-level summary.
should know what a Merlin report is, but I don't.
A
I'm afraid.
Merlin report is, my understanding, is a report that's sent by the police where there's a concern about exploitation or CCE.
Yes, thank you.
Thank you. And then, if I pick it up, I'll just take the the bits of the picture. So 23 sets out the evidence that was presented to the administrative court. So I've given the quotes and the references there. We can go to the statements, but effectively both of the parents referred to going out with, well, it was contemporaries, going out with friends and another boy. Those were the concerns at the time. There was no reference to any kind of influence or undue influence at the 18th of March GDC. And I've given you a quote there from what was said by the mother at the GDC, and I've given you a reference, it's 196. So she was specifically asked about what friends were causing the issues, and she says they were of the same age. And then 25 was a question to the chair of the GDC about that meeting, which is a summary from the chair of what you've just read. Then we get to the IRP, and if I could just interject here in terms of the IRP's decision, I think we all read the same paragraph, and we may have possibly reached different interpretations of it. And I just want to clarify how I interpret that paragraph. It's I'm jumping away from the skeleton laws, if that's
Okay.
Okay, just briefly, just to interject. It's 42 of the judgment of
Yes.
Miss Justice Forden's judgment. I'm taking you to the judgment all in one place and slightly easier.
Yes.
So what you've shown us is evidence at the IRP. Those passages that you've just taken us to in the skeleton,
Yes,
they were in the IRP hearing.
correct.
Yeah.
And I'm coming back to
Which
the,
led to their decision. And so far we've not looked at what happened at the redetermination.
correct. I'm jumping.
No, I
taking-
just want to make sure I'm keeping up with you.
Yes, exactly right, my lords.
Yes.
The IRP is a paragraph 7 of, as I think Miss Justice Forden marked them as numbers.
Yes.
In the original.
Very helpful.
So it's halfway down, and the 4 lines down. It was accepted by the IRP that the school had taken child criminal exploitation into consideration at the time when the principal made his decision, and by the governors of the GDC.
I'm sorry. I thought you.
Sorry.
That's 6.
Looking at Mr. Justice Fordham's paragraph 42, with
Yes.
which subparagraph?
7 of his paragraphs.
I think you said the IRP was concerned that the governors did not make inquiries. Isn't that what you read?
No,
I think you were halfway through the sentence.
exactly what I picked it up at where I was relying upon. But it's 7.
Okay.
The bit I'm starting is 4 lines down in 7, and it's
Sorry.
accepted.
Yeah.
Yeah, so what I submit on that paragraph is they were satisfied that CC was taken into account. There is then this, I say curious, but this strange sentence at the end about the curiosity about background needs and circumstances, but that would have to be seen in the context of the preceding paragraphs, where there were also issues about his emotional needs, pastoral support plan, the support in school, because all of these were also issues before the panel. So I think how I would frame it is that CCE was certainly an issue that was raised at the IRP, but I'm not sure I would say it was remitted on the basis of CCE, which I think is either a submission or I'm not sure. That was suggested this morning.
Well, what about the paragraph 43 of the judgment? And the concerning safeguarding, considering safeguarding concerns, CCE had been raised. The RIP were concerned the governors did not have to hand the school's safeguarding policy, etc., which would have supported them in meeting their statutory decision.
It was certainly an issue, my lord, before the IRP. I accept that, and it went back on a number of factors. I'm not what I wouldn't say is the IRP said. I think why I raise it is because I think it was either submitted or there's a suggestion that it was sent back on the basis of CCE. I'm not sure I would characterise it in that way. I doubt there's any disagreement about what they said. It's just how we characterise it.
Well, the question is what they meant.
I'm not sure it's the clearest decision, but there we have it. But I don't think anything changed on it, my lord. For reasons I'll come on to. And so then, my lord, if you're content, I pick it back up at 27 of my skeleton argument. So this is Lord Justice Holgate. This is where it comes back on the decision challenge. So the bit that you weren't referred to earlier in the deliberations was this bit I've extracted at 27, where it was specifically asked about by the chair of the DDC. Again, I can go to the underlying documents if we need to, but I'm not sure we do.
Yes.
And in terms of, and I won't go back to it, but you've seen it, the only reference in submissions before the GDC in relation to CC is that one reference where there was a reference to a risk of exploitation, which wasn't further particularised. And in terms of Miss Silliman, who has provided a statement to this court, she describes herself in that statement as a legal advocate. So it maybe she didn't have legal qualifications, but certainly there was representation before the GDC on behalf of the Child RWU. And we get to the point in my submission where I get to 28 to say that even at this stage, well, clearly everything changed on the 29th of July, because that was when the arrest occurred in Doncaster. And that's what led to the local authority. Well, clearly, things change at that point. But that is, even at this point, with the referrals and all of the extra documentation we've had that's post-decision, which I say isn't relevant, but even on all of that, there is no evidence, even at this date, of anything which amounted to any kind of imbalance of power before the 29th of July. The only indicators relate to behaviour and relationships with peers, and that's where I've tracked that through in terms of the documents.
say imbalance of power, you mean an adult pulling the strings, in effect?
Correct. Yes.
Yes.
But I technically I accept if it was a 17-year-old or a 16-year-old that could be relevant. But I'll take you to the guidance in a moment. But then I think the words that use imbalance of power. But yes, my lord. While I'm here, because I may as well finish off this point at the state of affairs at the time of the decision making. And this is, I deal with these in my skeleton with references, but I'll just summarise them. In terms of the cash that was found, the judge dealt with this at 27. We have a signed statement before this court that the mother says the cash was hers. So I don't see how, on any view, it can be an indicator of CCE. And to the extent it said, well, I think today it said, well, there was a difference of account, you should have probed further. What would that probing have found? It would have found that the cash was the mother's, which is as she signed off to this court with a statement of truth. So the cash can't be relevant. There was passing reference then, it's dealt with at Judgment 27, where CCE, the word CCE appeared in some of the, it's only the assistant principal used those words at the time of the decision. It said that meant the school knew that there might be CCE, but that was in, do you want me to go then, my lords? At 27, I think it was referred to this morning, which is why I raise it. 27 of the judgment.
You mean the referral to the
So it's the bottom
county's
quote.
SSO?
Correct, yes, secondly, it's near the bottom. So there's a reference in, and I'll give you the underlying reference is 26 of the supplementary bundle, if you want to see it in context. But that's the school did use those, the term.
Presumably the SSO is a designated person, or the academy has a designated person to go to.
Yes,
if they have concerns, and he or she is responsible.
that's correct. Yes,
Is that a safeguarding lead or somebody else?
yes, it's I'm taking sure whether it's the same person as the designated safeguarding officer. No, I'm sorry. The safest schools officer is a officer of the local authority. The DSL is the school safeguarding officer.
Yeah.
So if I can read that and check that's consistent with the judgment. Yeah, I'm getting.
I mean, the original text at page 26 says JPE contacted the school's SSO. I mean, that's still ambiguous. It could be a person at the local authority for the school.
That's right. I think at the local authority you have an SSO designated to certain schools.
Yeah.
But the difference is they're not a police officer, they just happen to be located at the police station.
The SSO. I don't think the SSO is a police.
Right, no,
I think the SSO is a local authority officer. So it'd be.
right. No, it was just slightly confusing because it said the APB had called the academy's SSO at the local police station.
Yeah.
I don't know. That's just, I've got slightly confused.
I think that may be wrong. So what it's on, if we're in the supplementary at 26, it's the second last paragraph of that entry and it's the last sentence.
So there's no mention of the police station.
There's no mention of the police station. Lord, yes.
So perhaps I should.
That's right. And my short point on that sentence is that all arose around the cash, which we've already established was the mother's. So the
Well,
reference,
also, one notes the following sentence in the judgment. Following the conversations with the social worker and the SSO, the cash was returned
yes,
to the claimant's mother.
exactly right. Yes. So it's not it was quite a big deal was made of that in the court below in relation to what the school knew about CCE, but the short point is it didn't. It related to the cash only. And then the only other point is in relation to A&E, the visits to A&E, and those were dealt with by the judge at 31 to 33 of the judgment. Again, effectively the visits were known by the local authority, but there was no parental consent for those to be passed to the school, and nothing was raised about them in the reconvened hearing. So that's where the GDC was at. And if you want the reference to the bundle on the consent issue, it's 149 of the supplementary. And that's why the judge concluded as he did. Question 8 and 9
Yes.
are relevant, and 10 in fact.
Yes.
And so I think that then deals with the situation at the time the decision was taken. What's repeatedly said below and in this appeal, that the school should have probed further, that was what was required of them. But it's unclear what evidence any further probing would have resulted in, because of the situation that occurred. And indeed, there's nothing, as I said, to repeat what I've said, there's nothing even at this stage that would have indicated a real risk of CC at the time of the 24th of June. The first issue which led to the local authority changing its approach was on the 29th of July.
I suppose it is being said that it might not necessarily have revealed incidents, but might have revealed risk.
Correct.
Risk of CCE.
But it's unclear what that risk would have looked like. What further facts would have given the risk?
Would have coloured the risk.
Yeah, exactly.
I mean, one way of looking at it, if the indicators referred to in the policy had been looked at, but there was no facts to link them to, it would be a sort of generic risk.
Correct.
Which might not attract the same weight in the balance under the PECS test as something specific to an individual.
That's exactly right, yes. So I start out by going through the 4 issues in relation to this ground of appeal. So the first issue, sorry, my lord, was there anything else on that point what we've covered? Otherwise I'll... no, okay. So the first issue is in relation to the legal question. It's all about the trigger test of credible suspicion. That's what this entire judgment depended on. The second issue to address is in terms of how does this court consider what the judge found on the facts. And so obviously this court under the CPR is dealing with whether the judge was wrong. There appears, at least in the written submissions, to be a dispute as to whether this court is simply remaking the decision, and I say that that's not right. I have in my skeleton cited the proportionality cases, but I'm happy to park those because I think I can get the same point out of Afriyie, which is the case my learned friend relies upon. So I'll take you to Afriyie as a joint effectively it's cited by the claimant. I'm happy to adopt that as the position. So
Yes.
a free is on tab 16 of the authorities. I was picking it up at 401, which is where, which is actually where the claimant directs you to as well. The paragraph, two paragraphs I'd propose to cite. I mean, the section is from 32 to 39, but I was picking up at 36, if I may.
This was a case about whether the police had used unreasonable force.
Correct.
When a taser was used.
That's exactly right. It's a different context, but I think expression applies here. So 36, it says that the principle applies to both findings of primary fact, but also evaluation of those facts and inferences. So it would apply in my submission to whether the facts amount to a credible suspicion. And 39 is in my submission the key paragraph as to what is, which is not a substitution. It's whether the conclusions drawn by Fordham from the evidence were ones reasonably open to him.
But are there not some situations in relation to ECHR rights where the court decides the question for itself?
So this is, agree, so I'm not...
And I think the Rwanda case is cited by the other side for the proposition that there are some ECHR rights where the appellate court decides the issue for itself.
on the first...
Lord Reed.
So on the first part in relation to the should the court take an objective approach, which was an issue before the court below, it doesn't matter for this appeal in my submission because the judge adopted an objective approach and no issue can be taken in terms of error. But for the purposes of the question he ended up asking himself, I'm happy to agree that there should have been an objective approach. So I take that out of the dispute. I think the dispute arose around the pleadings and whether it was a material consideration or whether it was more of a direct Article 4 breach, which I'll come on to. But for the purposes of finding whether there's a credible suspicion, I don't think there's no issue now that question is a question for the court. So that's, I think, the first part, my lord, of what you're saying. In terms of the appellate court, I hadn't been aware of another authority which said the appellate court is remaking the judge's findings. I didn't understand that to be being suggested, but I'm happy to be corrected if that's wrong. And my approach would certainly apply in proportionality in the cases which I've cited, the RR case, which isn't this case, but it's Article 4. And the other point just on this I would make is, and my lord, actually I can, so one further, in TDT, this was the same situation because the appellate court was looking at the judge's analysis of proportionality. And at 76 of TDT, it states that the error was not referring to a number of points in the judgment. So in TDT, the court was adopting the approach that I'm suggesting is the right one. to the extent it's helpful, if my learned friend in the skeleton argument uses the term an unsustainable conclusion, I'm content to adopt that as an approach if that's what's being suggested. Did the judge reach an unsustainable conclusion? And last point on this issue, my lords, is just there is a point about here, judicial review doesn't have oral evidence, so the role of the appellate court in those situations may be slightly different to where the judge has heard witness testimony. I take that point, but that is limited, and I've cited it as my paragraph 40 of my skeleton. It's a case called DB, where that is right, but there still needs to be some reticence of the court. I can take the underlying point, but my skeleton's probably sufficient. It's paragraph 40.
Yes.
So therefore, drawing those issues together, I say what this court is looking at is, did Mr. Justice Fordham make an error in his consideration of that trigger, whether the trigger duty, or whether the duty was triggered? And so then turning to the third point, or third issue, is how did the judge approach the question? He clearly identified the right test. There's no issue about that. He determined the points objectively evaluating for himself the answer, rather than reviewing on Wednesbury, and that's 61 of the judgment. Although, as I'll come back to in relation to the date, there was some issue, he considered the position at both the date of the exclusion and the date of the GDC. That was paragraph 83 of the judgment. And I adopt the observation of Lord Justice Stuart Smith in the order for this rolled up hearing, where it was said the judgment is closely reasoned. It is, it's extensive and very detailed in my submission. And the appellant does not point to any factor that Mr. Justice Fordham did not consider. The position is that he took everything into account, but it was just his ultimate judgment that was wrong. That's this appeal. And then I turn to the fourth of the issues that directly go to the ground of appeal, which is, what are the errors that are alleged to have been made by the judge? And I will just have to pick up, if it's okay with my lords, just pick up various points taken in turn. So I'll just deal with a few points which have been made. So the first one to deal with is in relation to the guidance. So the school's role, in the discharge of the protection duty, which we remember is owed by the state, is set out in guidance that's been issued. The judge, and there is no issue about this, considered all of the guidance that's suggested by the appellants. And in particular, he drew that together at 29 to 30 of the judgment, which, if it's okay, my lords, I will take you to.
The conclusion of the guidance, on the face of it, although it gives all these various possible indicators of child criminal exploitation, is pointing towards making sure that you refer to the proper agencies.
I entirely adopt that point, and I was going to make that. That's a paragraph 30 of
The Home Office guide.
Yes, schools. Sorry.
Schools guide.
all. Yeah, well, I'll take you to that in a
Yes.
moment. So 29 is this is the extract of the school zone safeguarding policy. So I'll adopt here, and it appears in various ways, but the point I made about the imbalance of power is that first sentence. So an individual or group takes advantage of an imbalance of power to coerce, control, manipulate, or deceive a child into any criminal activity, etc., etc. So that's what we're looking for, and that's what I say. There is no indication, even at this state, of anything that occurred prior to the 29th of July. Then there is a list, as there is in many of these different bits of guidance. So the list begins 7 lines from the bottom of the first paragraph, and this begins some of the indicators.
Yes.
So just to give as a litmus test, so the first indicator there, children who appear with unexplained gifts or new possessions, that's not satisfied here. Children who associate with other young people involved in exploitation, not satisfied here. Children who suffer a change in emotional well-being, that's satisfied on the evidence. Children who misuse drugs or alcohol, also satisfied. Children who go missing for periods of time or regularly come home late, well, there was one incident of him going missing overnight. And children who regularly miss school or education or do not take part in education. His attendance had lowered slightly during the autumn term, so that's partially fulfilled. I mean, the point I make about all of that is you look at all of the lists, some will be satisfied, some will not be. And ultimately it's a judgment on those lists. But even on that list, there is only some of those are satisfied. And then the other point on the guidance, and this is, Lord Justice Baker, your point, I think that may have been made, was 30 is a very good summary of the school's role in CCE, because it's not a first responder. No, I won't read it out, but I'll leave you.
Are the first responders relevant to the referral system?
Correct. Because the school's role is to report a concern to the local authority. That's what 30 says. And the bit that I rely on is the DSL. So the DSL is the designated safeguarding lead, which is an officer of the school. So the safeguarding officer in the school will refer to the local authority, who then, if it makes a judgment on whether to refer or not, that's the school's role under the guidance. And by the way, just on the Home Office guidance on criminal exploitation, which is the what Mr. Justice Fordham refers to there, extracts are in the authorities bundle, but the extract that he's referred to is not. So I've got hard copies of all of that guidance, if that's helpful, or you want that handed up, but it's otherwise available online.
If there's a hard copy bundle, and particularly if its contents have been agreed between, say, Miss McGibbon and Mr. Percy, I, for one, would be delighted to have it. My more digitally inclined colleagues may not think it's worthwhile, but
I'll take you to the bit that he's quoted. So the bit he's quoted is on page 12. And the sentence I particularly rely upon is this last sentence of the big first paragraph under modern slavery and human trafficking. So if you're not a designated first responder, which is the school?
Is first responder a defined term in the document?
It is. It's in this case, it's the local authority and the police. It's referred to in 30 of the judgment.
Yes.
And I can find, I think it may not be. I don't think there'll be a dispute on that. And so, so to the extent in the skeleton it's asserted that the school has a more extensive duty than the local authority, I quote, I don't agree with, I don't accept that submission. Its role is as a referrer to the local authority under the guidance. And then in terms of looking at errors on the part of Mr. Justice Fordham, I don't think there is any dispute that he referred to the relevant guidance and his assessment was correct. There was no issue taken with 29 and 30. So, my submission, any ground in relation to the guidance doesn't have merit.
Yes.
So the next discrete point that was made was how the judge dealt with the lack of referral from the police or the local authority, who are the designated first responders. And he described it, at paragraph 83, as a non-hindsight reality check. The fact that the system or the guidance puts in place agencies as first respondents, and they both did not make a referral and took the view that there was no material risk at the time, is in my submission clearly a relevant consideration that the judge was taken into account. And if you pitched it the other way, and actually on the facts say the local authority had made a referral, clearly the appellant would be saying, well, of course that was relevant to whether the school had any different duty. So clearly the judge using that as a reality check was lawful. And I particularly make that point here, where the local authority knew more than the academy. We know because
in particular in relation to the A&E.
A&E. So, my lord, I've taken you to the A&E example where the local authority knew more, and that is what the judge concluded as well. He referred to the A&E at paragraph 33. And at paragraph 66, he said, I quote, social worker 1 knew more about the claimant's circumstances than did the academy. That was his conclusion.
Yes.
And I say the court, it was entirely right and it's completely appropriate to give weight to their consideration. Those are agencies that are tasked with this job and are doing this every day. So it's entirely right. and it doesn't stop it being an objective assessment, that the court gives some level of deference to those on the ground where there are more than one agency who have the same facts and haven't raised an issue of risk. Then the next discrete bit, which it said there's an error, well, it said that he reached an unsustainable conclusion. I think I've now dealt with that when I made the segue at the beginning in relation to the evidence as it was at the time. We say the judge considered everything, and there's no dispute about that. The judge had everything before him and considered it in the judgment. And there's nothing we say to suggest it was unsustainable. And in fact, as I've gone through those documents with you, my lords, a few moments ago, I say it's entirely consistent with the evidence that was before the judge. And as I say, the not only in my submission does the court give weight to the position taken by the local authority and the police, who were the designated first responders, it can also give some weight to what the head teacher was, or the principal was considered at the time, who is someone on the ground and dealing with these issues. And I say there is deference. I quoted a paragraph from the Lord Carlisle case in my skeleton below on a different point. It's at page 230 of the core bundle, but effectively, I can summarise, in situations where there's a predictive judgment, it's an area where the court might give more deference to a decision maker. The next point was in relation to the quasi-prosecutorial process. This is the VCL point. I think I can deal with this fairly briefly if I just go to the case at paragraph 152, which it was said was the key paragraph. So it's at tab 18. And it's on page 480 of the 480 of the authorities. So I think we looked at this, but it's the second sentence, third line that's important here. So, in short, in order for that positive obligation to come about under VCL, it has to be demonstrated that the trigger has been satisfied. So it's not relevant to the trigger test itself.
Sorry, what's not relevant?
So the fact it may or may not be a quasi-prosecutorial process is not relevant.
Yes, you've still got to satisfy the threshold.
Exactly right.
Yeah.
I also note that it is a very different context, prosecutions and exclusions. An exclusion decision by nature is a sanction, but it's also ultimately a school management decision. which has to balance a variety of factors, including the harm to others. So for that reason, as VCL, I say, doesn't apply to the trigger test, but even regardless of that fact, it wouldn't have an automatic read over to school management. And we also note, this is perhaps a convenient juncture just to reiterate, this case is not a case about him being deprived of an education, because 5 days after the date of the permanent exclusion, which would have been late January 2024, the duty to provide full-time education fell on the local authority. So I deal with this at paragraph 7A, and Lord, I can unpack this as if I need to. But 7A of my skeleton, and I provide the references. The duty to educate falls on the local authority after a permanent exclusion, and that has happened in this case since January 24. And indeed, you will note you may have seen from the judgment, he was offered a place at something called the Southwark Inclusive Learning Service by the local authority. SILS, it was referred to, SILS. And he didn't attend, and the local authority issued a school attendance order to RWU's parents requiring him to attend. So that, I'll give you the reference for that. It's in the supplementary bundle at 279. So in April, well, shall I just take you through slightly step by step? So in the, I'll go there in a moment. So if I take you to 7A of my skeleton argument.
Yes.
So, and I can go to the underlying documents to the extent we need to. So, there is a duty on local authorities to provide education, which should be full-time unless exceptions apply, for children who aren't receiving education, including by way of exclusion. That's section 19 of the Education Act, which is in the authorities bundle tab 1. It's the very first page.
Yes.
That arises after 5 days following a permanent exclusion. You get that from the footnote of education provision, full-time education for excluded pupils,
yes.
And that's paragraph 5. So since late January 2024, I haven't worked out the exact number of 5 days, but since that time, it's been the local authority who's been responsible for his education. I don't understand there have been to be any challenge to any of the local authority decision making. They then provided a place for him at the Southwark Inclusive Learning Service, which was raised, I think, before the IRP or the GDC, and he didn't attend. And what Southwark did, they issued a school attendance order to the parents, and that's what I refer to as 279 of the supplementary bundle. And a school attendance order is effectively a prelude to a prosecution for not attending school.
Do you know what the Southwark Inclusive Learning Service is? Is it physical attendance at particular premises, and how full-time and so on?
It's full-time attendance. It's a pupil referral unit.
That's what I was wondering.
It is a pupil referral.
Didn't the mother express some concerns about the risk of her son attending that establishment?
That's correct.
Yeah.
But obviously that then is a challenge for the local authority.
I know, but it's perhaps something we should be aware of.
Yes. So there is an interchange, and maybe my junior can find it. There's an interchange where the governors were encouraging her to at least visit the service.
Indeed, some of the evidence we've been shown, for example, from the intervener, is that such places, I don't know if this is right or not, can pose risks because they're targeted by the criminals who are seeking to exploit.
So this may not be your best point.
Correct, although it's more the point I'm trying to draw out is simply that the duty to educate. There was a concern about the current state of the education. The duty to educate has been for now over a year on the local authority, and no challenge has been made to the local authority in relation to the current education. I'm not sure it's material to the appeal, but it was a question that was raised about his current situation.
Yes.
That then, I think, concludes, unless I've missed a possible discrete point as to what there might be in terms of an error, I think I've now addressed them all.
But can I make sure I've understood something? Because earlier on, you were taking us to the guidance and pointing out that the school's guidance, for example, and the Home Office guidance is in the context of referrals to the NRM. I mean, is the upshot of your submission that because of that, a school bears no obligations potentially under Article 4?
Of course, no.
No, because the judge said that they did.
Of course.
And what, for example, if the Doncaster incident in this particular case had happened before the GDP second decision?
Yes, so, well, let me then turn to, this was my other point.
That would be a relevant consideration for...
Yeah.
So whether you have, that's an example, it's a spectrum here, isn't it? You could have any very concrete evidence of a problem where something like Doncaster has happened, or you could have evidence prior to that, which is evidence of a risk. But in either event, in either situation, it could be relevant or necessary for the GDP to take it into account.
I'm happy to adopt that analysis, my lord.
And if they do take it into account in a PEC's decision, presumably their obligations aren't satisfied simply by saying, we refer this to the NRM. It's actually being taken into account in substance on the decision itself.
Yes.
Yeah, okay. I just wanted to make sure I'd understood. Okay.
Well, that then it neatly segues into the first of my 3 points that arose from this morning, which I say don't directly go to the trigger test, which is what we're looking for in terms of the errors, but arises from this morning. So the first of those 3 issues was, how does Article 4 fit into a permanent exclusion decision? And so if we start with and I think this has been, this then goes to the paragraphs of Mr. Justice Fordham's decision, which we were looking at earlier, where it was identified there may be an inconsistency. I'm not sure there is for these reasons. So if we start with the basic premise of Section 6 of the Human Rights Act, which says the Academy cannot act in a way which is incompatible with a convention right. Article, if you need it, it's Authorities Bundle 13, just for the reference. Article 4, which is at 16 of the Authorities Bundle, no one shall be required to perform forced or compulsory labour. So the most obvious way a school could be in breach of Article 4 is obviously not the case here, but if a school was engaging in forced labour directly, then obviously that would be incompatible with Section 6. It's a bit more nuanced, I say, where there's the protection duty, which is what we're dealing with here. So the protection duty is owed by the state, and we know that from TDT paragraph 14. It was also the conclusion of the judge at paragraph 60. It's not the Academy specifically.
Was it not owed also by public authorities generally as emanations of the state?
But yes, but then when you're looking, and you're looking at the appropriate measures.
Exactly.
Those are right.
It depends on the measures. I mean, obviously,
Correct.
passing legislation is not the function of the school.
Obviously, yes. And so it depends on what the public authority's powers are to act compatibly with. So if you start with the protection duty being owed by the state, so the school must not act under Section 6 in a way that is incompatible with the protection duty, the state's protection duty. And although the judge never got here because the judge cut it at its root in terms of the trigger test, I say that Section 6 duty could arise in one of two ways. The first is the school is aware that there is possible exploitation, and that becomes a relevant consideration, probably a mandatory consideration. Or secondly,
Would that be school becomes aware or ought to be aware?
or ought to become aware.
Or
Yeah.
reasonably to be aware?
So if the trigger duty is satisfied,
Yes.
that must be a relevant consideration in the permanent exclusion. But the other way in which it might arise is that the school's actions would form part of the state's appropriate measures. And that would be fact dependent on other agencies and etc. And that's what I say is in 59 and 60 of the judgment. So if I go back to that, use that framework to analyse those paragraphs. It's 59, 60 and 61. So if I pick it up at 61, this was the bit we're looking at in terms of there being a conflict. So the PECs should only be taken compatibly with Human Rights Act 1998. The GDP could not fail to reinstate if by the time of the consideration or reconsideration an HRA duty was owed by the school to the pupil.
Now, do you accept that sentence?
I accept that there might be a case that the appropriate measures are such that the school should not include as part of the state's overall appropriate measures. That's not this case. So if the appropriate measures that the state owed required the school not to exclude, say it was the only school for miles, it might be that is relevant. But it wouldn't.
Yes, exactly. You just said it. It becomes a relevant consideration.
Right. Yes.
See, that leads us down to the bottom of the snakes and ladders at 61, material consideration. Because with the PECS test, you've still got the issue concerned with the welfare and education of all the other pupils.
Yes. Well,
And it's possible to imagine criminal action far more serious than we're talking of here. Far more serious.
Yes.
And the idea that in that situation a school would absolutely become obligated to reinstate, no matter what the effect, as my lord was saying right at the outset of the hearing, what the effect on other pupils is difficult to follow.
It may be my clumsy wording. So,
Well, let's just focus again on this sentence. It's relied on by Ms. Braganza, but I question it. Indeed, it really went to her original case, which is if the threshold of a Human Rights Act duty is crossed, there is only one possible answer, and that doesn't seem to me to be right. As my lord has just said, supposing the facts were even more lurid, and a child, not the facts of this case, but a child comes into school with quantity of Class A drugs and every indication that he's a dealer, but also the school are aware that he may well be the junior member of a drug dealing gang being exploited by the adults. can't be right, as it seems to me, that the school is bound to reinstate him.
Entirely agree, my lord. Entirely agree.
Okay, well, you were going on to the rest of 61.
Well, correct. And in terms of bringing it to the practical situation of a school, where a school is at, where there is, and this is all on the basis that the triggers occurred. The school's role, as set out in the guidance, is as a referrer, and so that's how it fits into the state's appropriate measures, because it's others who are moving it forward, as it were.
But if that's the school's role as a referrer, or to others who then refer again, how does that impact on carrying out an apex decision?
Because it would then become but then I also
only as a material consideration,
correct, which is the last sentence.
Yes, exactly.
Yeah.
It all leads back.
Yes.
Yes.
So I think that's the first issue is how it fits in, and looking at 61. The next issue, which we discussed in the morning, are what are the appropriate measures. So I think if you would just put the wording in context. So VCL at para 152, I won't necessarily need to take you there, but it's appropriate measure, the state to take appropriate measures to remove the person from the risk of exploitation. So that's what the full phrase is. And actually, we may end up back where Justice Holgate.
Well, it could be remove or not exposed to.
Yes. Yes.
Sorry.
Yeah. Yes. I agree. And in terms of the written case, the appropriate measures which the appellant was asserting were covered in the reply skeleton argument at paragraph 22. And this is a direct answer, my lord, to your question this morning, I think. And it's 22, 4 lines down, the respondent will not necessarily. And this goes back to, on the facts, what, in real life terms, the school should have done. It had referred to the local authority. There's a suggestion, I think, in the BO submissions, the school should have investigated the CCE concerns, but that's not its role under the guidance. Its role is to refer to the local authority. And effectively, what I suggest is all 22 is saying, and this is why I said it goes back to your point, Lord Justice Holgate, is it's a relevant consideration it needs to be grappled with.
But it's elementary public law that when you take into account a material consideration, sometimes you have to ask yourself the relevant questions to be able to address that factor, which can include an obligation to inquire, obtain the information which is reasonably necessary to answer the question. Tame side.
But that's all rationality.
That's
common law is rationality.
It's rationality test, seeker 2.
Yeah. And I don't think this...
But I mean, I only raise that with you because you seem to be making an absolute submission that the obligation goes no further than to refer and couldn't possibly include inquiry.
I would differentiate obligations under Article 4 in the common law. So common law decision making, you would always have to take into acquaint yourself with the information.
Yes, but forgive me, you've cited the FOE case in the Supreme Court where you analyse Article 4 as an obviously material consideration in some circumstances. So then we're squarely in public law.
Yes.
I mean, I'd be surprised if there's some watertight divide anyway between the two.
But I mean, I say none of that arose here. I mean, the GDC did inquire at various points, and effectively the evidence was that it was peers, and that's reflected in the witness evidence before this court. And I come back to this point, it's repeatedly said in various of the grounds, bits of the grounds, well, the Academy should have grappled further, or it should have given conscientious consideration, but it's still unclear what any of that would have led to. I mean, we've dealt with the cash, where we have a signed witness statement stating it was the mother's cash, but even at this date, there's nothing to say, actually, you missed this very significant factor that happened before you took your decision. And that was because you failed to inquire. There's no outcome from any further consideration. The last of the three issues I said which came up this morning, my lord, which was in relation to the relevant date of the decision, if this went back to the GDC, are they considering matters now or at the 18th of January 2024? I think in terms of the article...
Well, 18th of January or 24th of June?
18th of January. So there isn't...
The original PEC's decision.
Yes.
But aren't the panel bound to take into account facts known to them at the time that they take the decision?
So I'll take you to the guidance on this.
Yes.
Effectively, and just to summarise the position, the guidance provides that the GDC is conducting a review. So you will recall Mr. Justice Fordham talks about these various reviews. And so there is a question which Mr. Justice Fordham, it was flagged to Mr. Justice Fordham, which he didn't determine because he said he didn't need to, in relation to whether the GDC on the 24th of June was looking at matters as at 24th of June or the 18th of January. I think, my submission is, if we're looking at compatibly with Article 6, Section 6, and we're looking at Article 4, I'm not sure if it went back, the GDC couldn't look at Article 4 matters as at the time it was taking its decision. But the reason it comes up is because the guidance frames the governor's decision as effectively a judicial review of the head teacher. And shall I take you to the guidance? That might be
but
easiest.
I think you will also need to take us to the legislation, because that's really what determines. I can't find a judicial review constraint in the legislation.
Agree. I agree with that.
In fact, it looks, to answer my Lord's question, is if one looks at regulation, whatever it is, 23, it looks as if they're taking a primary decision. The way Mrs. Justice Lang explained this very clearly in one of the cases cited by the appellant. There's a first decision by the principal, the head teacher, and then there's an obligation to submit a permanent exclusion decision to the GDP, and then they take a decision in accordance with Regulation 23. Is that right?
That's right, but you have an intervening piece of statutory guidance which possibly
overrides.
Well, it can't, but
delegated legislation.
The practice, and I think the practice of it usually doesn't arise because the governors are taking a decision very quickly after an exclusion, so it's not something that's common to a lot of cases. But the practice, I can't give evidence, but the practice of the clerks who provide services is generally to say you've got to take it at the 18th of January, which is why here you'll note that the Rambo knife incident wasn't taken into account because the GDC was taking a decision as at the 18th of January.
I'm sorry, I said regulation 23, it's 24, I think.
Better have a look at this. Might be rather important.
I mean,
I'm not sure any of this is...
It would seem very odd to me if Ms. Berganza is successful in obtaining an order that the appeal be allowed and remitted to a panel to consider whether the head teacher made the right decision on the 18th of January last year without regard to anything that's happened subsequently, seem a very odd exercise.
Well, I'll take to. I would caveat that position, though. I would accept. I think on any view, to be Article 4 compliant, it would need to be at the time of the decision, the new decision. So I'm not sure it's material in this situation, but I'll take you to why the issue has arisen in these kind of panels, and it may be, Lord, what I said to Mr. Justice, it may be helpful to have some guidance because I think there is a differing practice among IRPs.
well, the IRP is
Not the IRP, sorry.
is different.
Sorry,
the statute makes it clear they have got a judicial review function, I think.
Yes, that's right.
Which,
and they
I mean,
can't
the absence of that actually in the provision and dealing with the GDP perhaps tells you the answer.
Well, should I take you to what is there? And I'm really not making a strong submission either way on this, but I'll take you to the relevant bits.
Get it right.
24, I think, my lord, is paragraph 30. It's page 33 of the authorities, which is the one that Lord Justice Holgate has just referred to. In fact, it's.
And can I just see if I've caught up? These regulations are divided into parts. This part, part 4, is dealing with academies, correct?
No, it applies to all maintained schools, but for academies, principal is inserted rather than head teacher.
Because there's a part 2 which has parallel provisions, and that's what Mrs. Justice Lang writes about in her judgment. I got confused when I was reading her judgment, but this is part 4, as I understand it.
That
Anyway,
I will take it. I will get.
I don't mean to hold things up, but
so 24, I think, my lord, is the one for the first GDC.
and they're the proprietor, are they?
The proprietor is effectively the trust, the academy trust. And then regulation 26, and this is page.
Yeah, but do we need to look at 24?
Oh, sorry.
I mean, 24.2, the GDC must decide whether or not the pupil should be reinstated, and whether immediately or by particular. Then 3. I mean, those are the tests which the GDP are required to apply. Looks as if they're deciding all that for themselves.
And this is why I didn't disagree with you on your reading of the regulations, my lord.
No, you're very fair.
It would be contrary to common sense. You can imagine cases where between the original exclusion decision and the panel, the governor's disciplinary panel decision, something very significant has occurred. It might be to the pupil's credit, or it might be to the pupil's discredit. And there's nothing to my mind in this regulation which suggests that they have to go back in time to the principal's decision. Right.
And one bears in mind also the way the legislation is constructed is that if there's a decision by a principal to exclude permanently, it has to go to the GDP. Doesn't it?
Correct. That's right.
There's no appeal procedure to the legislation requires it.
Yes.
So it's an inherent part of the decision-making process that it is looked at by the GDP. Sorry, you were going to take...
I mean, I was also... You're right, it's a bit odd that in this case, the fact that RWU was found with a Rambo knife and after the decision of the 18th of January wasn't considered in relation to harm to others. But it was a favour that go against RWU, but no, as Mr. Justice Forbes said, no complaint was made.
Well, whatever the right answer is, it isn't dependent on which way it goes for particular individuals.
Exactly, yes. Yes, exactly right. So 24 and then just 26 then, I think I was just referring to, is actually what happened here, which was there was an IRP and it comes back to the GDC. I'm not sure there's anything materially different to what you just saw in the 24.
Where's the ID? Is it? Sorry, I've forgotten the acronym now. The
IRP?
IRP.
It's 25. It's
25.
It's in between them.
Yes.
And that's a review, isn't it?
That's the...
Well, it's rather odd that it's partly review on public law grounds, and if they think the way the GDC behaved wasn't serious enough to be a public law error, they can nonetheless, but still some error, they can recommend they reconsider.
Yes, there's a middle ground.
But here they went for the public law error.
Well, we don't have to consider whether the IRP can take account of things that have happened between the governor's first decision and their decision, because they're irrelevant in this case. Right.
Right, then I'll try to go to the guide. Before I do leave the regs, though, to answer my Lord's question, you're right about the part. Part 2 is, I think, probably what you saw from Mrs. Justice Lang,
Yes.
which is maintained schools. This is part 4, which is academies.
Yes.
I think is what.
Yes.
And I'm reading from them, they say the same thing.
Yes.
So,
I got that far.
right, and so if we go to the guidance then, which is, and this is statutory guidance at page 623. It begins, and the bit I'm going to go to first is paragraph 124, which is at 637.
Sorry, did you say
637, but it's the top pagination.
Yes, thank you.
Is 124. And this is basically the test that the GDC applies, according to the guidance at least.
Sorry, the document begins at 623, or at least the bit we've been given, but this is
637.
I see that, but whose document is this?
It's
and what
DFE's
date?
exclusions guidance.
Right.
And it's got to be
The what?
exclusions guidance published by the Department for Education.
Thank you.
And it's statutory guidance.
Yes.
So it doesn't answer the question of what date, but it sets out judicial review grounds. And then it might be relevant to look at the IRP just to compare. I'll give you 2 paragraphs if that's helpful.
Depends what you understand by the word reasonable.
Right. Yes.
Doesn't have to be.
Again,
It's an odd way of drafting something which is changing the regulation.
I'm purposely not making strong submissions. I don't
No,
know. I'm in agreement, my lord, with
Yeah.
broadly what you're suggesting.
Sorry, this is page 637 is any decision of the governing board, not just where there's been a review by an IRP.
That's
This
right.
applies to the first one
Correct.
as well.
Yes, it primarily applies to the first.
Right.
I mean, can I ask a simple question? Can you have fresh evidence before the GDP?
There's an answer, and the guidance tells you whether you can and can't for the IRP. It doesn't. I don't think it says either way. For the
But in
GDP.
practice, did they only look at material which was before the head teacher?
I can't answer that, and I
No.
think because the majority of these meetings happen so soon after, there's
Yeah,
not
okay.
generally been a significant.
Not if there's a reconsideration, of course.
Correct,
Which
and
is-
then there's a timeline,
Yeah.
like in this case, becomes much
Yeah.
longer. Shall I take you to the IRP? Your at least halfway answer your question about the evidence, my lord, if I take you to the IRP. So it's 640 is the IRP wording. And it's 208 is the answer to your evidence point.
Yes. Well, that's very clear.
And then I'll just give you the
And that's in
paragraphs.
deciding whether to quash.
Yes, and then the test, the IRP.
almost-
I'll give you the other reference below. It's
It's all
two.
topsy-turvy, isn't it?
Well, Mr. Justice Fordman, as you've seen from his review of the 4 stages, also didn't reach a dissimilar conclusion to you, my lord. 227 is the other paragraph I was just going to cite, and that's the last one that's guidance in relation to the test. But I think you have a handle on that. It is expressly judicial review principles.
Yes.
So, Lord, that's all very interesting, and I think if my lords are going to go there, I think guidance on the test is probably helpful to GDCs. But I don't think it's material for 2 reasons. One is that Mr. Justice Fordham looked at the matter on the 24th of June anyway, and there weren't any significant differences between the 2 decisions. We had the A&E visits, but he dealt with those in the judgment as to
Yes.
why those weren't relevant. And secondly, on this particular case, if this were to go back now, I can't see an argument to say why Article 4 at least shouldn't be considered at the time of the GDC, which is actually what this case is all about. Because that Section 6 duty must apply at that stage. I think that might be ground 1, unless there's any further questions.
Thank you.
So then, ground 2, which has now, I think, already been clarified, it is entirely contingent on ground 1. And to the extent that there can be any doubt, I'll give you a reference, we can go there if you need it. The appellants rely on a case called Zalitich in Azerbaijan and refer to para 185.
Really? Right.
Well, maybe
We haven't looked at that one.
Zalitich. So it's at tab 19, 542 is where I'm going in terms of paragraph.
So page 5.
542.
Thank you.
And this is cited, it's 7.3 of the reply skeleton argument as the base of ground 2. And so the point I take from it is simply that it's a procedural obligation arising where there's a credible suspicion. So it only arises if the trigger's been.
But this is a procedural obligation to investigate the perpetrators of the trafficking.
Correct, yes.
So this is
a different.
The state's obligation to prosecute those who traffic.
Correct, yes. So it doesn't, in my submission, it doesn't apply here.
It's not dealing with the protection duty.
Correct. The only other case that's cited for this proposition is DA and Secretary of State.
Is that Mr. Justice Forden?
Correct.
I mean, that was a permission judgment.
Interim injunction.
I don't know if he's given permission for it to be cited, but it's a long judgment for deciding whether something was arguable.
Yeah. Yes, but I'm not sure it takes anyone any further because that was based on policy. So to the extent what ground 2 doesn't do is create any kind of duty to investigate where there's no credible suspicion, and even if there was a credible suspicion, I'm not sure there's either of the cases say there's a duty on the school at least to carry out some kind of investigation. I fully accept Tameside would apply, judged on a rationality basis, but I'm not sure Article 4 adds anything to that. And we say the short answer to all of that in any event is that the GDC did consider the issue of possible exploitation. And again, I come back to the point that even if there were some kind of further inquiry, it's unclear what would have changed the risk matrix, even if we're looking completely in hindsight as at today's date. There's nothing that's being said the school missed, which would have made a material difference. I said I'd just have some points, having dealt with grounds 1 and 2, just mopping up.
Yes.
Unless anything further on ground 2. The first point is in relation to the BEO submissions. I say none of the submissions have a bearing on the legal issues, and particularly that trigger test, which we are concerned with. But I just make some overarching points about its expertise on CCE and the issues that we are dealing with. So its submissions, I was going to pick it up at 340 of the supplementary. This is a statement from Hindi Adiogun, which is the second statement.
Oh, yes.
It begins on 336, but I was going to begin at 340. And the points all go to the provenance and the provenance of the evidence and the expertise in CCE particularly. So at 340, there's para 17. It refers to a briefing on educational practices facing black communities in Britain with a citation. the short point on that is, if one goes to that link, there is a section on exclusion, but it doesn't have anything in it in relation to CCE. So in terms of expertise, it doesn't. That document provides no specific expertise on CCE. If one reads then down, for example, at 342, the repeated phrase in its submission, or the witness statement, is "in our experience." So 24 begins, "in our experience." 25, "our experience." Second line from the bottom, "our experience is that." But nowhere in the statement does it explain the extent of that experience in relation to CCE and exclusion. If I could then pick it up at 31, this is on page 344. This is in the context of BEO being obviously a charity centred on race. And CCE overarching submission is related to race but isn't directly a race issue. And if one, the reason I say that is at 31 there's a reference there to, it's a footnote 18, which is NSPCC in relation to county lines and CCE. Which states, and the premise that what's said about that is victims of CCE of black ethnicity are overrepresented. So if one clicks that link though, the statistics are 65.7% of victims are white, 22.3% are black, and then roughly 10% Asian and a small number of other ethnicities. And it's true that the NSPC say those of black ethnicity are overrepresented, but it is a much broader issue than that, than specifically in relation to black children. And I say in that context, whilst they have the repeated references to "in our experience," isn't a substitute for government guidance, which looks at the whole picture with stakeholders having input inevitably into that guidance, which sets out the roles of schools. Then the other more public interest statement that's been filed is in relation to the Quorum Children's Legal Centre, who have a specific expertise in legal representatives for exclusion decisions. The only point I make on that is they do raise issue in relation to local authorities not being supportive after exclusions, and that leads to issues. But I say, at least from the perspective of the academy, that's not a academy issue, that's a local authority discharge of duties issues, given the duties I've set out already in relation to section 19 of the Education Act. There's no suggestion by CCLC that the test is wrong, or should be interpreted in any particular way.
Well, we're looking at evidence and submissions filed by the interveners. Can we just turn to the written submissions of Mr. Seddon and Ms. Junior? We looked briefly this morning at page 330, and the submissions 14 about credible suspicion of the duties of inquiry. I appreciate this is going back to material that you covered in grounds 1 and 2, but I did mean to ask, do you want to say anything about this list in subparagraph 2?
So being possible appropriate measures. I mean, I'm content to. My suggestion is that if the duty is triggered, the case below looks why the dispute arose, it becomes a relevant consideration for the academy, and the steps it then takes would then need to be determined following that. So to take 2A to D in turn, have regard, the first one, have regard in considering the PEX to the role played by any CCE in the behaviour, then I don't have case specific, but in broad terms, there's no issue with that possibly being a material consideration. B, the inquiry.
And the second half, risk of further CCE that might result from PEX.
Again,
Assuming that the first half is satisfied.
the trigger is satisfied.
Well, the
then.
trigger plus also
Yes.
that CCE has had some part to play.
Yes.
Would the second part also follow?
Yes. Clearly, if a child is at immediate risk of CCE, the risk of what might happen following exclusion is clearly relevant. The inquiry, I think I've dealt with. I think that's a Tameside point. I don't think Article 4 on its own creates a duty on the academy to conduct an inquiry, neither just the guidance. C is more difficult because there's an assumption on the basis of what I've just said about the statistic. I think they would need to, I'm reluctant to make submissions on 3 because there's an assumption that
It's not very clear what 3 means.
Yes.
To me.
Yeah. And D,
But leaving aside the reference to race there, would it be relevant to consider whether in the circumstances PEX would have a disproportionate impact on the child?
in relation to convention rights?
Yes.
Yes, that'd be compatible with. So it must be. I don't have back to the the dangerous to high level statements, but no issue that the exclusion has to be compatible with convention rights. If that involves an analysis of proportionality in relation to one of those rights, then
Well, the proportionality is mentioned in TDT in connection with deciding what are the relevant measures.
yes, agree.
Yeah.
And the last one I don't agree with in relation to the academy because it's not the academy is not first responder.
Right. Sorry to have taken you out of the course.
I just refer. It is mentioned just for completeness because it was just raised in terms of taking into account the impacts of. It's mentioned in the written case at least. Taking into account the impacts of possible impacts of exclusion in relation to CCE, so you can become more vulnerable if you've been excluded. I say, Mr. Justice Fordham considered the guidance on that at. Let me get my notes. So it was the guidance on that specific point was considered by Mr. Justice Fordham. It's paragraph 10 of the judgment.
Well, this is obvious common sense, isn't it?
Yes. But it goes hand in hand with whether there's a credible suspicion. If there's credible suspicion, obviously you need to take account the impact on the child, but if there's no credible suspicion, I think the point falls away. Final, just two mop-up points. One is in relation to the permission threshold and the wider public interest. There's two brief points to take. One is that the Academy characterises this appeal as Mr. Justice Fordham did, which is an attack on the application of the facts to the test. So there's no issue in this appeal about the legal test that should be applied. It's all fact dependent. So whilst it's accepted CCE and exclusions in general terms might be matters of wider public interest, this appeal doesn't deal with, or this appeal is not directly on the legal framework which is agreed. It's just on ultimately what Mr. Justice Fordham decided in terms of applying the facts to the law. And secondly, to reiterate the point I've made already about the impact on this claimant, of course, there's no dispute that obviously an exclusion will inevitably have a significant impact on a child. But the duty to educate has been on the local authority for some time now. So if anything, this case is not about him being in full-time education. It's about whether he should receive full-time education at this academy.
Yes.
And then the final mop-up point before, if I may just turn my back, is just in the skeleton, the Academy does take points about how this claim was pleaded. I haven't dealt with those orally to be pragmatic and deal with the issues as they arise, but the Academy just still notes them in the respect that if one compares to, one tries to find the grounds of appeal in the original Statement of Facts and Grounds as amended or otherwise, there is not an obvious match, but I'm not asserting prejudice in relation to it, but I say there is an interest in procedural rights in these kinds of cases. If I may just turn my back.
You may. Yes.
And then, unless there's questions from the bench, that's...
Thank you very much.
My lord, I'll try to be brief in reply. First short point in answer to the last point is that the ground arises from the judgment of Mr. Justice Fordham, so the issue as to the evaluation and the triggering of Article 4. Article 4 was raised within the amended Statement of Grounds, and in the original Statement of Grounds. I don't say any more on that.
No.
The point about, again, working backwards, the point in answer to the intervener's submissions on appropriate measures and what they entail, and the last one, which was at 3302D, about the Academy alerting the local authority. The point there is that the what is set out is to consider whether to make a referral, and then I invite your lordships to read the footnote to that, and also to consider that whilst the school or academy is not a first responder, but obviously if it has a child in its school where there is a credible suspicion of that child being a potential victim of trafficking, that one of the appropriate measures would be to refer that child to the local authority.
That's part of
Yes.
the guidance of the schools.
Yes. The next point that I make is in answer to what appeared to be a point repeatedly made against the appellant, which is, well, what difference would this make? If you find that Article 4 was triggered, then in terms of appropriate measures and how the decision is assessed, as a starting point, the governors would have to have in mind that they are looking to their duty to protect the child. There's no consideration of that. I'd invite your lordships to look at the decision letter and look at the deliberation notes. It would, in my submission, have entirely changed the prism through which they considered the issues. For example, at the end of the deliberation notes, there's a reference to the boy not showing, I think the implication is not showing sufficient contrition, that he was tapping his foot. If more inquiry had been made into the overall picture, for example, maybe that he was behaving in that way because he was frightened or because he was anxious, or there may well be underlying reasons. That's one example of how the focus of an inquiry may well cause the consequences of that inquiry to be different. Another aspect is that I recognise what Mr. Justice Fordham said about the A&E visits, but, and no dispute can be taken on this, it is very clear that not giving consent, so mother not giving consent at the stage of the IRP, is not a barrier to data sharing when the child's needs are at stake and there's a safeguarding issue. So that is something that would have fed into the mix to be considered by the governors. And that in turn demonstrated even more clearly that he was at risk. Another point that would have been considered, and it was given no consideration, was the impact of the exclusion itself in heightening his risk of exploitation. Another point that again was given, it was given partial consideration, but it was not followed through to its logical end, was that in the decision letter, you will have seen that the GDP puts together the issue of the pastoral support coming to an abrupt end with his conduct on the 18th of January, also looking at his mother not being present at the time. And it seems to be an implication there, given that it's because his mother is not there, and this is why he behaves in that way. Again, looking at it through the eyes of Article 4 and the protection duty, it's clear that his mother's now returned, he has that protective factor, and that will feed into whether there are alternative measures to deal with this child before reaching the last resort of expulsion. And those are just some of the factors as to how, in my submission, my lords, it would have made a fundamental difference to how this GDP approached the question of whether or not this child should be reinstated in its inquiry, in its pressing of issues. So, for example, one of the governors in the deliberation minutes, I think, in fact, the other one picks this up as well, talks about, well, do we have enough evidence? And the clerk says, well, you have what you have. And again, that's another example of if this matter were, if the decision were quashed and it went back, aware of the Article 4 obligation, the protection duty, the governors would say, well, what is the evidence of this, of underlying need? So it's in my submission, it's not a sustainable submission to say that actually, even if there had been an appreciation of Article 4 being triggered and the protection duty, what difference would it have made? You were taken, my lords, to the statutory guidance on exclusions and specifically paragraph 227. I won't take you to it, and it's cited within the skeleton, but I invite you to consider specifically 259 AB 645, which refers to how the governors are to consider their decision once it's been quashed by the IRP. The next point that oh yes. My lords raised this point about taking a set of circumstances to the extreme of a child, and the example was given of the child with Class A drugs and the risks that might extend to the wider community and so forth. TDT and also the BEO submissions, and the reference there is at page SB330, referring to RUNCEF, sets out that appropriate measures are just that and are not intended to place a burden that is impossible or disproportionate. And in my submission, that answers the question, that it's not an absolute bar to exclusion. Certainly, you've heard my submission here that in the circumstances of this case, I say that he should have been reinstated when it was remitted to him, and my fallback on that is that it should be, the decision certainly should be quashed for it to be considered again. But it's appropriate measures. My next. The next point picks up on Lord Justice Holgate, what your lordship said about the submission as to the PRU and his mother being concerned about him going to the PRU, and also he was also concerned in his witness statement, he sets that out. For your reference, my lords, SB 342, and that's the witness statement from Ms. Adeogan, and she sets out that PRUs are often the stepping stones to prison, and this follows on the school to prison pipeline. The next point that I take strong issue with is that it is said that the local authority is doing this every day and they know more, and so the distinction is made as to how they meet their Article 4 duty and how a school is to meet their Article 4 duty. Again, this is something that we have stressed repeatedly in our skeletons as to the protective environment of the school. It is, in my submission, not right to say, certainly in this set of circumstances, that the local authority necessarily knew more. This was the school that, and the cross-reference to this is paragraph 6, AB 817 on keeping children safe in education, which sets out that the role of school and college staff are particularly important as they are in a position to identify concerns early, provide help for children, promote children's welfare, and prevent concerns from escalating. Part of the protection duty is also identifying whether they have before them a child at risk of exploitation. And that paragraph 6 of that keeping children safe also sets out that all staff have a responsibility to provide a safe environment. And making good on that in terms of the evidence, it is the school that knew about this rapid escalation in terms of his behaviour deteriorating. It is the school that knew about his having attended since he was 11, and that prior to that there were no similar patterns of behaviour in the way that there then occurred in very quick succession when his mother was not there. It is the school that knows that he presented under influence. Another safeguarding issue is falling asleep. He repeatedly falls asleep, and one of the suspensions is because of that. He presents with drugs on the 18th of January incident. It's not right to say that it was a one-off, that he went missing or he was late. There's a reference to that which I'll give you in a moment, where specifically the email which you may have seen from the designated safeguarding lead is to say that he tells the social worker that he's told the appellant's mother to report her son to the police. These are all things that were within the knowledge of the school, and that's putting any question mark on the cash to one side. That's looking at all the other factors. And so in my submission, they were, with their expertise in any event, they were in fact on this occasion, they were best placed. They could see that something was going very wrong, which is why he is described as a child in crisis. I also take very strong issue with the suggestion that because within the characteristics that have been flagged up and limiting those to the judgment, because there isn't a reference to evidence of an imbalance of power or adult involvement. And I think what was said was, that is what we are looking for. That is not, obviously, if that features, it's very, very plain evidence. But more commonly, when you review the characteristics, that's not what they point to. They don't point to evidence of adult involvement or imbalance of power. What they point to are the lists that you've been taken to repeatedly, which we say match our circumstances, and that is accepted by the respondent, that some of the factors mirror the characteristics, and we say that is enough, again, to meet the threshold. The fact that this imbalance is not there, or adult involvement, is not only wrong to rely on, but also, in my submission, it underlies a fundamental misunderstanding of what I said at the very beginning this morning, of this being a process, the way that county lines and the way exploitation develops. And it develops very often through peer group involvement, and we knew that he had that. He was brought back by the police, so there was involvement on their part as well. So to be looking for a perfectly presented package which has on its which is labelled exploitation, is to be looking for the wrong thing.
Why? I thought your case was focused on the risk that he was a victim of CCE, that is, exploitation by older people.
Not necessarily by older people, it's by an individual or a group. But what I'm saying is that the fact that the school at that stage, that there wasn't direct evidence of that, cannot in any way be determinative or indicative of him not being at risk of CCE. That's the point that I'm making. So what I'm saying is that the characteristics that he demonstrated, so the way he is, the worsening in his behaviour, the number of suspensions, presenting under the influence, falling asleep, all of those, they match the trigger threshold. And to say that there's no incident, there's no particular incident to point to, or there's no adult involvement to point to, that can't mean that the threshold is not met.
Are there any cases of misbehaviour by a teenage pupil in which it's not met in that case? I mean, it could be said that say, take two examples of bringing drugs into school or bringing a knife into school. Is the school bound to inquire in every case whether somebody else might be involved who might be exploiting the child?
My Lord, it will depend on the circumstances of that individual child. I rely on the circumstances of this appellant to say that he ticks so many boxes that the threshold is met. The fact that he doesn't tick, the fact that at that stage there isn't known evidence that he ticks that particular box, I say, it's quite wrong to rely on that as saying the threshold is not met.
but it's a judgment. You've got the indicators, but there's a judgment involved. I mean, you may only have 5 out of 10 indicators. You might say that might be enough, but the view one takes about that is a judgment, isn't it? And indeed, if you apply the Tameside Katoon approach, whether you decide to go further into it to see if there's more lying behind, again, is a judgment, and it's a judgment as to how far you go into your inquiries. Would that be fair?
Yes, and to take it further, in this case, the relevant paragraph of, is it 61, where all those indicators, you're looking at some, I'd counted some 14 or 15 factors where I agree. If a boy comes in and falls asleep and is suspended for it, I'm not for a moment suggesting that the protection duty kicks in. But if a 14-year-old black boy who's previously been recognised he could be at risk, who has not shown any previous behaviour of this kind, where he's being defiant with teachers and walking out, and his mother is worried about him. His mother has raised that she's concerned about the friends that he's spending time with. The school has told the mother to report him as missing. He turns up and he's carrying, as I say, put aside the cash, he's carrying drugs on him. He gets distressed, he gets anxious. All of these things are potentially on their own, they could be red flags, but certainly in the circumstance of this case, there are so many red flags that you take them together, and that's why we say.
You're saying a lot of these things were completely out of character. There'd been nothing like this before.
Well, but there hadn't been. It all happens direct. That is the timing as well. And there's I've talked about the generic evidence. He comes, there's nothing in the first term. He comes back after the half term, and then within weeks, it just escalates. And it coincides, as I say, it's absolutely crucial. His mother is not there when this happens. So he doesn't have that protective factor. And he's behaving completely differently from what everyone has thought before, to the extent that he's actually flagged up as a bright boy with, I can't remember exactly the words verbatim, something with charisma and it's a shame, and I think the emails on the managed move, and you can see that on the part of the school, they recognise something's gone wrong, and that is encapsulated in the IRP, when the IRP says this is a child in crisis. The point in this case, my lord, is that to exclude a child in crisis has to be done once all the other alternatives have been properly considered, and once the reasons that child is in crisis have been properly explored.
Well, that sums it up in a nutshell, doesn't it? Sums your case up in a nutshell. Is there anything we haven't covered?
I think no, my lord. I'm sure you fully have my points.
Right. Thank you all very much, both for the oral submissions from Ms. Briganza and Ms. Bannister, and for all the written work and support work from their respective teams. We will reserve judgment. We will send out a draft judgment prior to handing down. Two things about that, which I'm required to say they're very well known to counsel at least. Firstly, the draft judgment is sent out for parties to put forward corrections of typos and obvious factual errors like wrong dates or wrong names, that sort of thing, not for re-argument of the case. Secondly, the draft is confidential to the parties and their legal advisors. In the case of the appellant, it's fine for him to know and his parents to know. On the academy side, it's fine for the principal or governors or anyone who has to give instructions about ancillary matters to know. We leave that to the solicitors on each side to determine. Any ancillary matters and the form of order should be agreed if possible. If it isn't possible, then brief written submissions on each side. It should in no circumstances we can envisage be necessary to have a further hearing at which people are required to attend. I think that deals with everything. We're very grateful to you for your assistance.